maybe it's
I
better
know,
on
that's
paper.
what I was-
It's just not a good one. We need a new one. Actually,
It's quite a drive from Gualala to here.
yeah.
It's a little windy.
Did you take
A Mountain View Road.
Oh,
Yeah.
that's a good one. If that one saves time rather than going
You
around.
all set? Let me double check I've got it going
Yeah,
here.
look at this one.
Yeah, I'm actually very familiar with that house. I've
Looks
heard
like
about
life.
your plans to rebuild it. I think it's great.
We're good to go.
It definitely
You can
is,
submit
it
comments right now.
definitely is the house that needs the most work in the neighborhood.
Yes.
All right,
But
so
great
I'm
spot.
gonna,
He's our neighbor.
I'm, okay. I'm gonna go ahead and, I'm gonna bring our coastal permit administrator hearing to order of July 24th, 2025. It is 10:01 a.m. Do we have a determination of legal notice?
Yes, all items have been properly noticed.
Thank you. And we have one item on today's agenda, which is case CDP 2023-0041 and variance V 2023-0002. And our staff planner is Shelby Miller. May I have your presentation, please?
Sure. Good morning, Coastal Permit Administrator, Project Planner Shelby Miller here. The project site is located in the coastal zone, approximately a half-mile northwest of the Gualala Town Center, and approximately 0.1 miles west of the intersection of Pacific Drive and State Route 1 via Coral Court. Located at 38660 Coral Court in Gualala. Assessor's parcel number is 145-16409. The standard coastal development permit requests to pave a driveway, demolish approximately 600 square feet of an existing single-family residence, remodel interior and exterior of the single-family residence, excavate for a lower story, and then construct 2,636 square feet addition to the existing residence, which also includes the 2 bedrooms, a garage, an art studio, solar panels on the roof, and a 3rd level guest cottage, which will be sited on the proposed garage. Concurrently, a coastal development variance was included in the project request to reduce the front yard setback from 20 feet to 8 feet due to the constrained lot size, shape, and topography. 4 other properties within Coral Court have been granted setback variances due to difficult topography, sizes, and shapes of the parcels within that community, including the property to the east, which was granted a 0-foot front yard setback for a garage. Thus, the proposed variance would not constitute a grant of special privileges inconsistent with the limitations upon other properties in the vicinity and zone in which the subject parcel is located. The project is located within the rural residential land use classification and zoning district with a variable density of suburban residential. Considering the parcel size is a ½ acre and is served by a public water utility, which is the North Gualala Water Company, the property shall be developed to the suburban residential standard. Single-family residences and associated utilities are principally permitted within the suburban residential classification. The proposed guest cottage and garage are incidental and subordinate to the single-family residence. The variance request for the reduced front yard setback, would not conflict with the coastal element of the general plan and would support other components of the coastal element, such as chapters for hazards and grading, erosion, and runoff. Thus, the proposed project is consistent with the intentions of the suburban residential land use classification. The project was referred to all applicable agencies, including the Mendocino County Department of Transportation, the California Department of Fish and Wildlife, and Coastal Commission. Noteworthy recommendations from the Department of Transportation include that the applicant shall construct a residential driveway approach onto Coral Court in accordance with the Mendocino County Road and development standards. The applicant shall have the front property line along Coral Court marked out by a professional land surveyor. And also the applicant shall obtain an encroachment permit from the Department of Transportation office for any work within the county right of way. And also, county staff and Department of Fish and Wildlife went on a site visit and to basically understand the topography and issues of the property. And of course, Department of Fish and Wildlife understood the constraints, considering that the property abuts Robinson Gulch and has very steep topography, and agreed with the reduced buffer analysis, and recommended enhancing the natural communities on the project site. All avoidance measures were incorporated into the conditions of approval from the geotechnical investigation and biological reports that were prepared. The proposed project is categorically exempt from further California Environmental Quality Act review under the California Code of Regulations, sections 15301 and 15304 for existing facilities and minor alterations of land. Therefore, staff recommends approval of the project. Thank you.
Thank you. Okay, and then next we'll look to the applicants, and this is your opportunity if you have any questions or comments regarding the project or conditions of approval, and just please state your name for the record.
Okay, my name is Dave Ashukian. I am co-owner with Mary Ashukian, and I do have some questions. They're more about procedures kind of going forward. It's not about the approval per se.
Sure.
I'm not sure if I should raise those questions now or later.
We could probably, if they're just procedural regarding the conditions and not concerned about the language within certain conditions. Otherwise, I would say if you're concerned about any of the language, now would be the time to discuss it.
Okay, yeah, I would say I'm not concerned about the
Okay.
language.
Yeah.
I'm just concerned about what it means.
Well, why don't you, I would say go ahead
Yeah,
and ask
let's
them.
go ahead. Okay,
Let's make sure we get them all straightened
so
out.
my understanding is that we have 2 years to show progress before the permit expires.
Correct.
And then it mentions about the ability to renew the permit. Can you just briefly explain that process? Is it an elaborate process, or is it just a matter of like a file and maybe pay more money? I don't know.
Sure, so a renewal process is an application to our office, so there is a fee associated with it.
Yeah,
And it does go through review with the various agencies that previously have reviewed the project.
Okay.
So there is always the potential that additional conditions may be added as a result of going through a renewal process,
Okay.
or that additional information may be requested.
okay, all right, understand.
But provided you vest your permit, meaning you conduct a portion of the physical work associated with your permit within that 2-year period, you're not subject to needing a renewal.
Got it, okay. My understanding from the building department, and we built our own house before, once I start construction and we start moving, it doesn't have an expiration date per se, as long as you're actually making progress. So if it takes more than 2 years to complete the house,
Oh, that's fine.
It's
Yeah.
fine.
Yeah,
It's
that's
fine.
just fine,
okay,
yeah.
okay. We have come up with a couple ideas where we want to make a modification to the plan, and I'm wondering how extensive that would be. Do we just go with the building permit process and make those changes there, or do we have to come back here?
So it depends on the scope of the changes, but typically I would suggest that you would vet those past Shelby.
Okay,
And she would conduct a review to see if it's in substantial conformance with your approval,
Yeah.
or whether or not it's something that would trigger going through a full modification
Yeah.
process. If it does trigger the full modification process, you can always choose how you want to adjust from that.
got it.
But a full modification would be a very similar process to what you've gone
Okay.
through.
We want
as
to
part
add a
of this, yeah.
staircase from our deck to downstairs, and it's it'll be outside of the setback areas.
Mhm.
And just wondering, how complicated it would be to add a staircase coming down. That's the
That's
proposal.
pretty much it.
So far, that's all.
Yeah. that's what-
Also, it's possible that we might want to raise the floor of the existing building like 6 inches or a foot, and it would still be within the height limitations of the overall project. But it's possible, based on the way things work out, we might want to raise it up a little bit.
Okay.
Those are the two things that I've come up with. The requirement that our deed be modified to address the guest cottage as opposed to calling it an ADU. My understanding is the Wallala local ordinance is the constraining factor that prohibits the ADU. If Wallala changes that ordinance, is there any other restrictions, or could we then go forward and make that an ADU?
You'd have to come through our process, which, if that did change, right now we have where there is a ministerial type of CDP process if you meet certain factors.
Got it.
Otherwise, it is going through a coastal development permit process or a modification to your permit. So you would just have to come back through if that does change in the future, and then as part of that, we would look at the portion that's been recorded on your deed and about removing that if it was
Right.
possible
Okay.
to permit
Okay.
it. Yeah.
All right. On condition number 4, there's wording that says compliance is mandatory. And does that mean that all the conditions, I mean, I just questioning that to say, hey, I don't have to build exactly what I propose, I can make changes, maybe make it smaller.
Yeah, what we
Or-
call substantial conformance. So,
Okay.
yeah, so
Okay.
that, yes, this is a standard condition that we add, but
Okay.
there is the opportunity to talk with us about minor, adjustments that may need to happen that is within overall substantial conformance with the approval.
Okay. And then section 31F, that one says that, what was it? 31F says the requirements of subsection D, which I'm assuming is the one two above, says shall not apply to residences or associated improvements on the property that predate this application. So does that mean that our existing building, this doesn't apply to our existing building that we're keeping?
Let me read this one.
And it's subpart F to that.
Yeah. Oh, okay. Oh, this is it's a standard one for deed restrictions regarding the geologic and erosion. So it's like, they shall not construct any bluff or shoreline protective devices to protect such permitted residents and all of that stuff, right?
Well, yeah, and so, and it's funny because I was actually going to ask a question about this one after we heard from the applicant.
Okay.
So with it stating that the requirements of subsection D shall not apply to residences or associated improvements on the property that predate the subject coastal permit, and subsection D is really the portion that talks about removal of the house and foundation when bluff retreat reaches that point where the structure is threatened. And so my question to you was going to be, is that typical that we would accept the existing residence?
Oh, if it were to pose a threat or something?
Mm-hmm.
Dang it, I think it is a standard one.
Just kind of.
Well, and you can think about it for a little bit, and we can keep going
I mean,
as well.
honestly, it
but-
doesn't make that much difference.
Yeah, but,
to us, but I'm just curious in the long term.
Yeah, because this is something, I will say, this type of condition is something that we have been applying rather regularly, and actually it's called out in the Gualala Town Plan as being something that is applicable to development down in Gualala, because as, just how natural erosion processes work, at some point your structure
I
may
get
be threatened by bluff retreat.
We understand.
And so it's really to set the standard that you are responsible
Understand.
for removing anything, if it's, any portion falls to the beach.
I get that.
Yeah.
It's just, I just couldn't understand. It says, oh, the existing property is exempt from that.
Yeah, and
What does that, no, I interpret that to mean I could potentially protect the existing house, but not the new construction. I don't have to remove the existing house if it falls, but if the new
Yeah.
part falls, I have to remove that.
So, and
just
how,
don't-
how
yeah.
that currently reads is it's only applying to that subpart D of that condition, so it's not addressing the bluff and shoreline protective devices. That is prohibited, so you cannot construct bluff or shoreline protective devices. Subsection D is the portion that just talks about
Got it,
removal
got it.
of the
Okay,
residence
okay,
and such,
all right,
yeah.
I understand that. Okay.
But yeah, and all, while we keep going, if you have any other questions or comments too, I'll just look up that code requirement.
Let's see, 36. So 33, actually, I did have a question regarding the marking the property lines. We'd had a survey done and the corners were marked. And so is that gonna be sufficient, or do I have to have the survey come out and do it again?
That can be sufficient. You'll just have to, I think you'll have to send it to the Department of Transportation,
Okay.
Mendocino County Transportation, to verify.
Okay, all right. Yeah, I already talked to Alex from the
Oh,
Department of
perfect.
Transportation.
Great.
And he's like, oh, yeah, I put this in, he told me about, the requirement for the driveway, and he says, if you wanna fight that, I'm not gonna fight you with it,
Okay.
But, I said, well, I'm not gonna argue with it here.
Yeah.
But, I was just curious about, like, it's pretty clear where this
Yeah.
is.
Yeah.
And I just wanted to make sure that, anyway, okay.
And then if you don't mind, I'll just back up to the item we were talking about before, and I pulled up the code section, and that language comes directly out of the zoning code, so.
Yeah.
So the language that talks about the requirements of subsection D shall not apply to residences or associated improvements on the property that predate the subject coastal permit comes right out of our zoning regulations.
yeah.
So that is just talking about that, I think because you have maybe an existing structure that predates the Coastal Act requirements and
Right,
such, so
right.
it's giving you a little bit more leeway because of
Understand.
it's not under this coastal
I
permit.
understand, yeah. I was curious, because our neighbor, 2 years ago, the storm took a big chunk, and they literally are 3 feet from the cliff. And I'm thinking, if that was my house, I'd want to do something about
Yes,
that.
yeah.
And they're like, well, I don't know, I'm in fact thinking, based on the permitting process, I don't think you can stop that from happening. So anyway, the last one was 36, the record a notice of exemption.
Sure.
So what is that about? I don't know what
It's
exemption.
it's an optional filing. So underneath the California Environmental Quality Act, when we determine a project is categorically exempt from the California Environmental Quality Act, there's an optional filing to file a notice of exemption. And it gets filed with the county clerk and with the state clearinghouse. And what it does is it reduces the time period during which someone can challenge a project based upon CEQA-related
I see.
grounds, and shortens that from 180 days to 35 days.
Okay.
But it's an optional filing, and so it's certainly at your discretion whether or not you want to go forward with that. So this is sort of a optional condition whether or not you would like to do that.
And then it would only matter now, right? Because it's 180 days from today, is that?
Correct.
Okay, all right.
Yeah.
I think we'll do that, but other than that, I think that's all questions
Okay.
I have.
And any other comments that you want to add from the applicant? No? Okay, perfect.
I want to thank you guys for actually, when we first started this, we felt like it was going to be daunting, and I didn't find it to be all that daunting.
Great.
So,
We always like to hear that.
Yeah.
So, I hear the reverse a lot.
Plug along,
Yeah.
Okay, well, great. Thank you for your comments. So now I'm going to go ahead and open up the public hearing and see if we have any of members of the public who wish to speak on this item. And please just state your name for the record.
Yes, my name is George Provencher, and I'm a neighbor. I live on the other side of the ravine from the address where you have a building permit filed. Just one comment is that all along that ravine on both sides, there's been a history of owners who have needed variances in the past because the setback requirements, but it's actually beneficial to grant variances to have a smaller setback on the street side because it gives more room for dealing with vegetation and erosion issues and that sort of thing, and on the other side or the back side of the property. My next door neighbor requested a variance years ago, and he was building his home, and I certainly didn't object to it. I think I know of several homes that are right on the street, literally. The only thing that I'm a little confused about is I've heard different versions of what the setback entails. I've heard some planners say setback from the edge of the street, and some have said from the middle of the street. Which is it?
The corridor preservation setback runs from the center line of the roadway.
I thought that was it.
Yeah.
Yeah, I always thought it was the center line.
Yeah.
So really, it's not it actually gives you quite a bit of leeway.
So I was under the impression that it's from our property line.
So there's two different setbacks that we're talking about. Yeah.
Okay.
So there's the corridor preservation setback, which is from the center line of the roadway, and then you also have a front yard setback in addition to that, which is from the edge of your property line, and they're calculated cumulatively. So you
So-
have to meet both the
Yeah.
the
so
corridor
8
preservation
feet,
setback.
is that from our property line or from the road center line? That's not from the center line.
No.
because
No, I think that's from your
Property
property
line.
line.
Okay, all right, that's right.
I just thought it'd be good to get that clarified.
Yeah,
Thank you.
yeah,
It's
that
always
is
been a
good.
question
Yeah.
in my mind.
Sure.
But there's been a real history of people needing to have that variance or being closer to the street, and it is beneficial. And I've never heard of anyone ever objecting to it. And you know, I had this notice that I assumed because I was probably within so many feet of your property
Yes.
and you know, an opportunity to voice an objection. Or I've never, of all the neighbors that I've known, no one has ever objected to something like this. It's always been looked upon as being beneficial.
Great.
So, and I have no objection whatsoever. I think it's great. It's great that you're rebuilding this house. By the way, you're granting this permit, and the way you're working together really helps the neighborhood. You're increasing my property value, and I want to thank you very much. Anyway, nothing but positive things to say. As a neighbor, I'm very supportive of this.
Great. Well, thank you for your comments.
Okay.
And then I'll just note for the record that we have no attendees on Zoom, so no members of the public joining us on Zoom. So I'm going to go ahead and close the public hearing and bring it back to the Coastal Permit Administrator. Since we went through some questions that I had myself, I'm glad we answered all of my questions. So with that said, I want to thank staff for the thorough staff report and presentation today. I've reviewed the entire packet and will approve the project subject to the findings and conditions contained within the staff report, and finding that it's categorically exempt.
Yay.
So with that, your project is approved. So now your next steps here are there's two different appeal periods. So the first one is a 10 calendar day with our local board of supervisors. Once that concludes, we send a notice to the Coastal Commission, and then you have a 10 business day appeal period with the Coastal Commission. So roughly about 30 days from today, you'll have a final and effective permit that we'll be reaching out to
I
you
have a
for.
question. What was this exempt thing that you want to do, the shorten? I don't understand what the file, what is that?
Well, and we could follow up on that probably right after the meeting here.
Okay.
Let me just finish our last couple
Sure.
procedural things, and then we'll come back to that.
Okay.
So, okay, great. So I'm going to go to our next item on the agenda, which is matters from staff. Are there any matters from staff on the?
Not today, thank you.
Are there any matters from the public? The Coastal Permit Administrator welcomes participation in meetings. This item is limited to matters under the jurisdiction of the Coastal Permit Administrator, which are not on the posted agenda, and items which have not already been considered by the Coastal Permit Administrator, and no action will be taken.
Actually, I have one matter.
Sure, please just state your name again.
Yeah, George Provencher. I live in Walla. Julie, you may recall my involvement with the heliport licensing project that we did with RCMS years ago.
Yes.
You were present at the meeting when a resolution was passed by the County Board of Supervisors agreeing to have the Walla Plan Development Zone rezoned under a different classification of properties that were owned by RCMS and also in the surrounding area, which is called the GPD. And the Board of Supervisors, also in that resolution, they said that the cost would be handled by the county for rezoning, and they tasked the planning department with doing that. It's been, I believe, somewhere around 6 or 7 years. That resolution needs to be resurrected, and I was wondering if I could ask you to perhaps ask for a search within your with the County Board of Supervisors Secretary, if they could resurrect that resolution and review it for action, because I don't think any action was ever taken on that. I could be wrong, but it's very important for the future growth of our CMS. That area requires presently a set-aside for 50% residential in an area where we have ambulances and fire trucks rolling and a helicopter landing. It's not a residential area. But it creates restrictions on their ability to expand their square footage. We need more exam rooms. Community is growing, whether we want it to or not. It's the population has gone from, in that time period, it's gone from less than 500 people to over 2,200 people in the city limits of Walla, or the town limits of Walla. So, and RCMS is faced with some insurmountable future growth issues, especially if we don't get it rezoned. So I'd just like to just respectfully request that perhaps if you could have your staff do a little research on that, we'd be very grateful.
Yeah, well, I will certainly talk with some of our staff members, because I know that question has come up, and they've done some other improvements, I think, relatively recently up there as well.
Yeah, good,
Yeah.
okay.
Great,
Thank
thank you. And yes,
I just
go
have one
ahead.
more question or comment.
And please just state your name for the
Dave
record again.
Dave Ashukian. And my question is, I have spoken with Kevin Evans, who is the president of the Wallala Municipal Advisory Committee, regarding the local ordinance for restricting ADUs west of Highway 1. And actually, when they approved, or when they reviewed our project, they made comment, and I had to explain to them that we're not doing ADU because of the restriction. And they made comment that, yeah, we understand that existing ordinance, we would like to change that. And so my question is, I assume that the Wallala Municipal Advisory Committee then makes a recommendation to the County Board of Supervisors, and then they have to make that change? Or what's that process?
Sure. So either I think, the Gualala Municipal Advisory Council can always provide that they would like to see that change, and they can send that to us. They could also send it to the Board of Supervisors. Ultimately, our work plan is set by the Board of Supervisors and what they'd like to see. But it is, anytime you're updating an ordinance in the coastal zone, we have our local review process, which requires, analysis by staff, hearing with the Planning Commission, and then the Board of Supervisors. But in the coastal zone, you have to go one step further and also submit for certification through the California Coastal Commission before any regulation becomes effective. So I think our original ADU ordinance took us about 3 years to complete that process. And there is right now, we're in the process of updating our local coastal program. So certainly this is an appropriate time to be having some of those conversations as well.
Okay, all right.
So-
Yeah, they recommended that I come back and make a public comment
Yeah.
at their meeting, so
Yeah.
they could start the ball rolling
Yeah.
on their part.
Yeah,
Okay,
okay.
thanks.
It's the right time for it. So
Yeah,
yeah.
It's ironic that we can build the same exact footprint and building, and yet we can't rent out that
Yes.
room. We could rent out the whole house, but
Yes.
not that room.
Correct. Yes.
Yeah, that's a little weird.
Yeah, we could live in that room and rent the house, but we can't
Yes.
live in the house and rent the room.
Is there any other matters from the public? Seeing none, okay, then I will go ahead and adjourn the meeting at 10:29 a.m. And give us just a moment to close out here.